Imagine this. You've just married the love of your life. You've come to the United States on a spouse visa, or you're waiting anxiously for your green card interview. You've done everything right, or at least you thought you did. You've provided your financial documents, answered every question truthfully, and you're finally starting to believe that maybe, just maybe, your American dream is within reach. But then, you get a letter. Not just any letter, a denial, or worse, an RFE, or even a notice to appear in immigration court. Your heart sinks. You think, how did this happen? I followed the rules. I love my spouse. I'm not a fraud. But here's the harsh truth. Starting January 2026, the rules for marriage-based green cards are changing. And if you don't act now, if you don't know what's coming, you could lose everything. Yes, I said it. Lose everything. Your chance at a green card. Your ability to stay in the United States legally. Even your ability to ever apply again without facing harsher scrutiny or long-term bans. This isn't fear-mongering. This is reality. And if you're watching this video, it's because you or someone you love is counting on a marriage-based green card to build a life in the United States. So listen carefully, because what I'm about to tell you could change your future. Let's start with what we know so far. The U.S. Citizenship and Immigration Services, USCIS, is gearing up for major updates to how they handle marriage-based green card applications, especially those filed under the Form I-485, application to adjust status, or those applying from abroad, using the Form DS-260, immigrant visa application. These changes are expected to go into full effect around January 2026, though some policies are already being tested or rolled out in phases. Why does this matter to you? Because the way USCIS investigates and verifies the legitimacy of marriages is about to get a whole lot stricter. Now let me be clear, the US government has always required proof that a marriage is bona fide, that it's real, not just for a green card. But in 2026, they're stepping up their game. Think more interviews, more document requests, more in-depth background checks, and, most importantly, a zero-tolerance approach to anything that even looks suspicious. That means if your paperwork isn't perfect, if your story doesn't add up, or if you miss a single deadline, you could be flagged, delayed, denied, or even referred to immigration court. Let's break this down into the key areas you need to understand right now so you can protect yourself, your family, and your future. First, what exactly is changing in January 2026? While USCIS hasn't released an official all-in-one document titled New Marriage Green Card Rules 2026, we have enough signals from recent policy memos, USCIS training materials, stakeholder meetings, and official statements to know that the agency is shifting toward a more aggressive enforcement model. Here's what that means in plain English. Right now, not every marriage-based green card applicant has to go through what's called a Stokes interview. That's the super intense, sit in the room together and answer every personal question kind of interview. But starting in 2026, more couples will be required to attend these high-pressure interviews, especially if their initial application raises red flags. USCIS officers are being trained to look for inconsistencies in the smallest details, like the color of your spouse's car, how you met, who pays which bills, or how you celebrate holidays. If your answers don't match, even slightly, you could be denied. Requirements. USCIS is placing a much heavier focus on the I-864 Affidavit of Support. That's the form your U.S. citizen or green card holder spouse signs to promise they can financially support you so you don't become a public charge. But soon, they're going to dig deeper. They'll not only look at your sponsor's income, but also their tax returns, assets, debts, and employment stability. If your sponsor recently changed jobs, has a low income, or owes back taxes, you'd better have a rock-solid backup plan, like a joint sponsor or tons of assets. Otherwise, your application could be delayed or denied. Accounts, lease agreements, and photos. You might think submitting a few joint bank statements, a lease, and some photos from your honeymoon is enough to prove your marriage is real. And sure, those things help. But in 2026, they might not be enough on their own. USCIS officers are being trained to look for patterns of authenticity over time. That means they want to see years of shared financial responsibility, not just documents created last minute for the application. If all your proof is brand new or looks staged, they're going to suspect fraud. AI tools. Here's something a lot of people don't know. USCIS is using advanced technology to detect fraud. They're analyzing patterns in applications, cross-referencing data across agencies, and even using artificial intelligence to flag applications that seem suspicious. That means if your application looks similar to others that were recently denied for fraud, or if certain patterns don't add up, you could be flagged before you even get to the interview stage. We're already seeing a huge uptick in RFEs and anoids in 2024, and it's only going to get worse. In 2026, USCIS plans to issue decisions faster, but that doesn't mean they're approving more cases. It often means they're denying more cases quickly or asking for massive amounts of additional evidence before they'll even consider approval. If you get an RFE, you usually have only 30 to 60 days to respond. Miss that deadline, and your case could be denied by default. Now, I know what you're thinking, but I'm already in the process. My case is pending. Am I affected? The answer is possibly yes. If your case is already in line, you might not see the full impact of the 2026 rules right away, but new policies are already trickling down into current adjudications. That means even if you applied in 2023 or 2024, you could still face stricter document requests, longer processing times, or additional interviews based on the new standards. So what do you need to do right now to protect yourself? Let's talk about the most important steps you can take today to safeguard your immigration future. If you've already applied for a marriage-based green card, whether you're adjusting status with Form I-485 or waiting for an immigrant visa interview, you need to be tracking your case like your life depends on it. Go to the official USCIS website right now and use the Case Status Online tool. Enter your receipt number. See if there's been an update. Has USCIS requested more evidence? Has your interview been scheduled? Has your case been transferred to another office? These are all critical pieces of information. If you see that an RFE or NOID has been issued and you don't respond in time, your case could be denied without you even knowing. Don't wait for USCIS to ask you for something. Start gathering every piece of evidence you can think of that proves your marriage is real. That means joint bank account statements, not just 1 or 2, but multiple months. Lease or mortgage agreements showing both names. Utility bills in both names. Photos together, lots of them, over several years, not just from the wedding call logs, chat history, travel itineraries, affidavits from friends and family. Any proof of shared responsibilities, like picking up each other from work, caring for family members, or making major financial decisions together. The more evidence you have, the stronger your case will be, especially if USCIS decides to dig deeper. If you've been scheduled for an interview, treat it like a job interview for your life in America. Practice your answers. Make sure you and your spouse are telling the same story, down to the smallest detail. Know your addresses, your work histories, your financial situation, and your reasons for marrying. If you're nervous, do a mock interview with a trusted friend or even an immigration attorney. The last thing you want is to freeze up or give conflicting answers. This cannot be stressed enough. If USCIS sends you a notice, whether it's an RFE, no ID, or interview notice, you must respond by the deadline. If you miss it, even by 1 day, USCIS can deny your case automatically, and once it's denied, you might have to start the entire process over. Or worse, you could be placed in removal proceedings. Step 5. Consider talking to an immigration attorney, especially if you're unsure. Let's be real. The immigration system is not designed to hold your hand. It's confusing, it's slow, and it's full of traps for the unwary. If you're unsure about anything, your eligibility, your documents, your interview, or how to respond to an RFE, talk to an experienced immigration lawyer. Yes, attorneys cost money, but so does a denial. And in many cases, having the right legal guidance can make the difference between approval and deportation. Now, I want to address something that a lot of people are worried about but don't want to talk about: fraud. USCIS is on high alert for marriage fraud. They know that some people try to fake marriages just to get a green card, and because of that, they're looking at every application with a skeptical eye. That doesn't mean you're guilty just because you're being questioned, but it does mean you need to be 100% honest, 100% prepared, and 100% transparent. If you lie on your application, even about something small, it can result in a lifetime ban from the United States. And one more thing, do not travel outside the U.S. while your green card application is pending unless you have advance parole. I've said it before, and I'll say it again. If you leave the country without advance parole while your adjustment of status is pending, USCIS can consider your application abandoned. That means you could come back to the United States and find out that your green card process has been canceled altogether. Final thoughts. Look, I know this is a lot to take in. I know the fear, the stress, the sleepless nights. I know you're putting your trust in a system that often feels cold, confusing, and unfair. But you are not alone. Millions of people have gone through this process. Millions more are doing it right now. And with the right information, the right preparation, and the right mindset, you can succeed. But you have to stay informed. You have to pay attention to the deadlines. You have to know what's coming in January 2026, and you have to act now. If you found this video helpful, please hit that like button. Share it with someone you know who's going through the immigration process. Subscribe to Immigration News Today and turn on notifications so you never miss an update. We're here to bring you the latest news, the most accurate information, and the strongest guidance every single week. And most importantly, leave a comment below. Tell me what you're going through. Ask your questions. Let me know what immigration topics you want us to cover next, because your voice matters, your story matters, and your future in this country depends on the choices you make today. Thank you for watching. Stay strong, stay informed, and never give up on your dream.